Progress. Okay, yeah. Then definitely. Yeah, I'll do like half, maybe.
Hey, I'm still here.
Hey Andrew, can you hear us?
We'll do a song.
If you want to test the.
Do you want to do that one or?
Hey Andrew, can you hear us?
That way we can. What's up? Just the chorus? Yeah, sure. But those days are gone.
Hey Andrew, can you hear us?
So
Hey, I'm here.
Yep. Give me 1 minute. We're testing the musician.
I can tell.
People think we're strange. They don't understand. Yeah, I'm gonna do.
Try and sing.
Okay. Which one?
Just sing whatever. The one you're gonna do.
Yeah, we'll do this one. Yeah, we'll try. It goes. Where did you go? I looked away and you were gone. You didn't say where did you
Good morning, everyone. We will be starting in about 5 minutes or so. My name is Abhishek Mathur, and I'll be your MC today.
No matter what I do, baby, never be enough. Standing on the edge, break and run. Should have learned by now. Don't owe anyone.
All right, good morning, everyone. Please take your seats and we will get started. It's 11:01 Central Time. Yeah. Again, please take your seats. Good morning, Oasis. All right. Good morning, everyone. My name is Abhishek Mathur, and I'll be your MC today. As you might have seen on our website, or you might have heard about us from your friends, and yesterday at Friday as well. We are a 501c3 nonprofit organization, and we are Houston's own secular community. There we go. There's Jennifer reminding me to be a little louder. So we run by our core values. A couple of them I'd like to mention here. People are more important than beliefs, and human hands solve human problems. And we have been practicing these through our various events today, and we host great speakers like today's speaker, Andrew, and we'd like to get started with a couple songs today from Joe Crump, who plays around town, and sometimes as a solo artist, and sometimes with his band, The Drift. And let's get started with 2 songs from Joe Crump.
And Nathan Ray. It's great to be back here with y'all. Thanks for listening. We're gonna play some covers and some originals, so hope you like it.
This is a song called Stones Around the Sun. Life was falling down. That sighing sound was too loud. War was breaking out. You found your crowd. I turned around. Where did you go? I looked away and you were gone. You didn't say, where did you go? I don't know. Where did you go? I looked away and you were gone. You didn't say, where did you go? I don't know. When you pull back far enough, we are only stones around the sun. Pull back far enough, we are only stones around the sun. Life came tumbling down. You know I tried to fight my way out. Somewhere in this cloud, a piece of sky I heard about. Where did you go? I looked away and you were gone. You didn't say, where did you go? I don't know. Where did you go? I looked away and you were gone. You didn't say, where did you go? I don't know. When you pull back far enough, we are only stones around the sun. When you pull back far enough, we are only stones around the sun. We are only stones around the sun.
Nathan Ray.
Thank you.
So this is an original song called Lost in an Art Museum. It's a true story. this whole place until you see the stone. On the canvas in the sky, you better stop to wonder why we're living a life of pain. We're living a life of pain, and love is all around. Gotta find it, 'cause it's hiding in the basements of our heart. Baby, let's get lost in a big art museum. We can lose our bearings, notice there. And I think that we have a lot to discover if we open up our hearts and minds tonight. Imagination taking flight. I never know what to say. I never know what to say when people disagree. I think I'm wrong, I'm holding on to what I want them to be, but they shouldn't close their eyes. But they shouldn't close their eyes to all the majesty everywhere you see in the world, and yet unfurled for us to feed our weary souls. Baby, let's get lost in a big art museum. We can lose our bearings, notice fair. And I think that we have a lot to discover if we open up our hearts and minds tonight. Imagination taking flight. To the beautiful art, can feel all the holes in your withering soul. If you keep it away, then your soul will decay, and it's never too late to enjoy the buffet that's been laid out for you. And if you only knew what ubiquitous beauty and passion could do, you make more of an effort to take in the view, 'cause your life loses meaning if you don't pursue all the love. Love, the love of the world. Baby, let's get lost in a big art museum. We can lose our bearings, notice there. And I think that we have a lot to discover if we open up our hearts and minds tonight. Imagination taking flight. Thanks so much.
All right, thank you, Joe and Nathan, and they'll be right back after our main speaker. Without any further ado, I'd like to introduce our main speaker, Andrew Torrez, who's founded his own law firm in the DC area. He's a graduate of Harvard and George Washington University. He's also the co-host of the very popular Opening Arguments podcast, the legal podcast that helps you make sense of the news. And given all these week's events, it's a very timely topic, and we would love to, we're grateful that he could make it to our talk on a very short notice. And so go ahead, Andrew.
Thank you very much for having me. Can you hear me okay?
Yes.
Great. Let me share out my slides. And while we're doing that, I just want to thank Alexis Boggs-Podeman, Houston Oasis, for inviting me here today. Slides look good?
Yes.
Great. So I'm very happy to be here with you virtually to give you an update on the Supreme Court's 2022 spring term. Also, big thanks to Joe and Nathan. You guys sounded great. A lot of folks over in the YouTube comments are pointing out that they're digging the music. And we could use some music right now. Just like the last time I spoke here at Houston Oasis, well, that was in person, I have lured you under false pretenses. Here is the actual title of this speech. Yes, the Supreme Court hates you, yes, you personally, and what very little you can do about it. Now, Before we get into that, the Houston Free Thought Oasis is a 501c3 nonprofit educational organization, and nothing in this speech is or is intended to advocate on behalf of or in opposition to any political campaign or any candidate for public office. And of course, nothing in this speech constitutes legal advice or creates an attorney-client relationship. Don't take legal advice from this speech. And the puppy's there for two reasons. First, a lot of you listen to my show, and that is indeed Lily, the opening arguments puppy. And second, times are really bad, so I have included an adorable picture to help ease the pain. Part one. Can't believe it's not milk. This is the Supreme Court. It looks like the Parthenon. That's on purpose. If you Google it, you will find that the single phrase that is most often used to describe the Supreme Court is that august body. Now, august means dignified, impressive, noble, worthy of respect. But I am here to tell you today that there was and is only ever one reason to respect the Supreme Court. This is the Caroline Products Company, today a wholly owned subdivision of Eagle Family Foods Group, LLC, former manufacturers of, I swear to you, I'm not making this up, Milnut, a sludge of condensed skim milk thickened with coconut oil. Congress banned it as, quote, an adulterated article of food injurious to the public health, end of quote. It was basically the Malk of the 1920s and 30s, right? Chemically formulated with vitamin R. Use it to replace milk in all of your recipes if you cannot afford milk, like, pretty much everyone during the Great Depression. And there's something else that you need to know, which is that from 1897 to 1937 was what we lawyers call the Lochner era of the Supreme Court. It was 40 years of right-wing judicial activism in which the Supreme Court invented nonsensical constructions of property rights and struck down pretty much every progressive law for 40 years as being unconstitutional. Everything good? Okay. Minimum wage, unconstitutional. Maximum working hours, unconstitutional. You couldn't regulate workplace conditions. You could not ban child labor. And let me emphasize some math here. The Lochner era ran for 40 years. By contrast, the Supreme Court has only been in full-on howler monkey mode for the past 5 years, since Mitch McConnell stole Merrick Garland's Supreme Court seat and gave it to Neil Gorsuch in 2017. So if you think, this is one of those things where the pendulum just kind of swings back and forth, and I'm sure it'll fix itself, or, hey, really bad outcomes now will accelerate the socialist revolution in 2 years. There's 40 years of abject misery that would like to beg to differ, and that happened to us less than a century ago. So now, back to Caroline Products. They were indicted for selling this crap in 1936, and they argued that the law was unconstitutional. And you'd think they'd have to feel pretty good about their chances before the right-wing hacks that, constituted the Lochner Court, right? I mean, if you can make kids work 90 hours a week in the uranium mines, what's a little vitamin R, right? Except Caroline Products couldn't have known that it was going to have his case decided in 1938. That's the year that Franklin Roosevelt threatened to pack the court if it didn't change its ways. And shockingly, the Supreme Court suddenly stopped just making up the constitutional right of corporations to work 12-year-olds to death. Now, that probably happened, and it probably helped, that Franklin Roosevelt had just won the presidential election by an unprecedented 2-to-1 margin, 523 electoral votes to 8. Put a pin in that. So the really important thing here isn't that the Supreme Court said it was okay to pass laws against selling milky sludge. In fact, if you're feeling as depressed as I am about recent events, it probably will not surprise you to learn that the Caroline Products Company changed the name of their flagship product from Milnut to Milnot, got bought out by Borden Milk, got bought out again by Eagle Foods, and right now, this very minute, you can whip out your cell phone. You can go to www.milnot.com and order up some tasty Milnot from a participating store near you. Make sure you get the original, though. It's the only oil-thickened skim milk product with soybeans and 100% of the recommended daily allowance of dipotassium phosphate. Because you see, this is never really about Caroline products, the product. For all I know, Milnot is delicious, right? And its mutagens give you superpowers. I don't know. Lawyers don't care about that. What we care about is why the Supreme Court decided what it did. And actually, we don't even care about that. What we really care about is this little footnote right here, footnote 4, the most famous footnote in history. Remember, this number right here, this is the only good reason at all that the Supreme Court has ever had, has, or will deserve your or anyone's support. So let's take a look at what it says. Hey, I said this footnote was important. I didn't say that it was easy to decipher, but here's what's going on. Okay, in the main text, the Supreme Court in 1938 finally realized something that should have been super obvious to it for the past 40 years, which is, you know, the Caroline Products Company, a wholly owned subsidiary of Eagle Family Foods Group LLC, does not need the Constitution's help. They've got money. They've got influence. Either they can persuade Congress to let them sell Milnut or Milnot or whatever, or maybe Congress will make them go back and change it, take out a couple of carcinogens. But look, this is precisely the kind of thing that we should leave up to the democratic process, right? And so for economic regulations, the Supreme Court announced a rule in 1938 that, so far anyway, is still the rule today. And that is, if Congress can show a rational basis for your ordinary economic regulations, the corporation has to follow the law, right? Rational basis, we don't want to work kids to death in the uranium mines. Legislation, minimum working ages, minimum wage, maximum working hours, workplace conditions, all of those were about to get approved by the same Supreme Court that had just spent 40 years striking them down. The Supreme Court was also worried about something in this case, right? And that's why they wrote this footnote. And here's what it says. It starts off with, look, we want to be super careful here with what we're saying. Congress can't do anything on a rational basis, only the stuff we think you can probably fix with the political process, like the whole Milnot, right? If you're talking about, and now we're in the second paragraph, laws that restrict your right to vote, well, or laws that otherwise interfere with the political process, it would be pretty stupid of us to say, use the political process to fix that, right? Instead, we might use, and this is their language, more exacting judicial scrutiny of those kinds of laws. And that makes total sense. And now we get to the third paragraph, and this is the part I've highlighted. The Supreme Court in 1938 recognized that sometimes the political process doesn't work well for people who aren't white men in corporations, right? For discrete and insular minorities, that tends to, quote, curtail the operation of those political processes ordinarily to be relied on to protect minorities. Again, I get it. It's 100-year-old legalese. Here's what that means. If you're pro-Milnut, you might find yourself in the majority, like now, I guess, right? Or you might find yourself in the minority, like in the 1930s. But there's no sense that you're permanently stuck in one of those groups, right? You can persuade people to join your cause, and your opponents can do the same thing. So those minorities are fluid. But when a minority is discrete, that is, comprised of members who are easily identifiable, and insular, that is, capable of being written off by everyone else who isn't a member of the group, and incapable of changing that identity, we think that the democratic process can't always fix things. And that's where the Constitution comes in. This is the legitimate role of the Supreme Court, to step in on behalf of discrete and insular minorities and say, hey, we're going to protect you from the stuff the majority might want to do to you because you're different. And the Supreme Court didn't just make that up in 1938. You will hear how this court claims to value history and tradition. Well, you don't get more historical than the literal founding fathers who wrote the Federalist Papers, the documents that were the arguments for ratifying the Constitution. And you may recall a Mr. James Madison who went on to become president of the United States. And here he is, when he's asked to describe one of the reasons to ratify the Constitution, some of the problems predating the Constitution, he says, quote, complaints are everywhere heard, end of quote, that our laws, quote, are too often decided not according to the rules of justice and the rights of the minority party, but by the superior force of an interested and overbearing majority. And so the founding fathers, the ones this Supreme Court claims to revere, set aside a special institution to occasionally, every once in a while, take those rules of justice and enforce the rights of the minority against even the majority. And that brings us to part two. So I get emails, and when we started the show, I get a lot of emails from conservatives who wanted to argue that abortion wasn't a constitutional right. And by some completely inexplicable reason, they all started off with the same terrible argument. And when I say terrible, I mean laughably bad on the level that other lawyers will point at you and snicker. Not me, though, because I'm super nice, and I was very patient. And that argument was this: where does it say abortion in the Constitution? And the response here, really simple. Constitution does not say abortion. It also does not say a word about dating, marriage, condoms, clothes, hair color, adult toys, or everyone's favorite, butt stuff. And so I would say to them, suppose a state, let's say it rhymes with schmexes, decides to ban at one go interracial dating, interracial marriage, condoms, adult sex toys, wearing off-the-shoulder dresses, coloring your hair, purchasing vibrators, and, of course, butt stuff, all at once. And by the way, these are all real things that states have either tried or have successfully banned over the years. Not making any of this up. Does that really seem like the land of the free? Does it really seem like you have any liberty? What does it mean to be in a free country if you can have a state impose those dozen restrictions on your most personal aspect of your life? And then I would show them the text of the 5th and the 14th Amendments here. And I'd ask them a question. I'd say, what do you think the founding fathers meant by that word liberty? Now, I will tell you, the first pushback you get, this is not a knockdown instantly. The first pushback you would get is, oh yeah, well, that just means the stuff that's written in the Constitution, like freedom of speech, things it actually said, not stuff you make up, right? And then I say, all right, let's think about that argument for a second. If the government tries to censor you, to take away your freedom of speech, you would sue under the First Amendment, right? Those are First Amendment claims. That's why we call it that, right? That's the one that says Congress shall make no law abridging the freedom of speech. And they'd say yes. And I'd say, and you'd never hear anyone say you need something other than the First Amendment to protect you against being censored, right? They'd say, yeah, no. And so I would say, right, so think about that. If liberty only means the rights that are otherwise specified in the Constitution, then these amendments are literally worthless. They don't protect anything because anything already spelled out is protected in the section that spells it out, right? It doesn't need to be included in the definition of liberty. And you know what? They would slowly come around. And then I would get to the argument that says, okay, but liberty can't just be whatever a judge makes up, right? Like, that's crazy. And of course, that's an Antonin Scalia talking point and has been one for 40 years. But now, my trap was sprung. That is from the concurrence in Griswold versus Connecticut. And those internal citations are, in some cases, almost 100 years old. And what it shows is that throughout pretty much our entire nation's history, liberty in the 5th and 14th Amendments means the stuff that isn't written down, that is not specifically mentioned in the first 8 amendments. That doesn't mean that it's up for grabs or for a judge's personal whims. Rather, it means you ask yourself, are these rights fundamental? Are they implicit in the concept of ordered liberty? Are they intensely personal and private? Is it like the list that I just went through? And for 100 years, this worked pretty well. Wish Samuel Alito had emailed my show. Yeah, right there on page 1 of his majority opinion in Dobbs, issued on Friday, 2 days ago, is Roe is terrible because the Constitution doesn't mention abortion. Literally the dumbest argument anyone ever leveled at a podcast, and it just got made by our Supreme Court. And you're probably guessing, with the box being in the upper left-hand corner and all, that Alito goes to this well more than once, and you would be correct. In major sections of the opinion, Alito's argument is that because the word abortion is not explicitly in the Constitution, it must be viewed with extreme suspicion unless it is, quote, deeply rooted in our nation's history and traditions. And so we get to, and again, this is the only paragraph in the Dobbs decision that matters. The legal conclusion: because abortion isn't in the Constitution, isn't said by name, we need to look to see if it is deeply rooted in the nation's history and traditions. Because it was criminalized in 1868 by the vast majority of states, it can't be deeply rooted in our nation's traditions. Therefore, it's not a right. Each and everything that I mentioned in that long list as also not being in the Constitution was also, by the way, the subject of criminal punishment by 1868. Contraceptives, interracial dating and marriage, and of course, simply existing as an LGBTQ person. Clarence Thomas says as much in his concurrence, although weirdly, he leaves the interracial marriage part out, which I'm sure is unrelated to the fact that he is married to a white woman. I want to make 2 observations about this new test that the Supreme Court has forged by deliberately ignoring our nation's actual history in its zeal to overturn the right to an abortion. Point 1, by requiring a right to be deeply rooted in our nation's history and traditions in order to count as implicit in the concept of ordered liberty, it means that by definition, only those who don't need the Constitution's protection can possibly get it, right? You have to prove that the liberty you want protected by it is a thing that was already being protected during the ordinary political process. This is the exact opposite of footnote 4 of Caroline Products. And point 2, deeply rooted traditions means the traditions that were in place at the time the 5th and 14th Amendments were ratified. That's why 1868 is so important, right? This means, in no uncertain terms, that only the traditions of white, male, cisgendered, heterosexual, landed property owners will ever count to this Supreme Court. This means the traditions of slave owners count in defining what liberty is, but the traditions of slaves do not. So when I said that this Supreme Court hates you personally, I was not being facetious or hyperbolic. If you're a white, male, cis, hetero, landed property owner, you're probably okay, unless you're an atheist, so oops on that one. You will not find a lot of well-established atheist traditions in 1868 either. And if you're everyone else, you never had a chance. So now what? First, some more disclaimer stuff. You know, if this was a church, I wouldn't have to do this, but we aren't. So I am cognizant that this is a speech before a 501c3 organization. This is the text of 26 USC 501c3 up here. My point is not to influence legislation or to promote any political campaign on behalf of or in opposition to any candidate for public office. Instead, I'm going to talk to you about candidates in the past, that's fair game, and principles for the future. That's also fair game. And some of you are not going to like this. I was asked to give this presentation about 40 hours ago on a Friday night in between 2 3-hour recording sessions. And by the way, I still run a law firm too. I said yes so that I could give this part of the speech because I intend to fight with everything I have to try and take back what we've lost. And a lot of that work is work at the grassroots and local level. building communities, working with organizations that, for example, transport women and pregnant patients across state lines to states that protect the right to an abortion. Listen to opening arguments for more on that. But politically, there is one and only one thing that you can do, and it is not much, and I know it, but you have to do it anyway. Look, I get that people are hurting and are desperate and angry right now. But this exchange on Twitter is literally the worst possible take. The person who wrote this, someone I consider a friend, finds out about this speech, he's probably going to be mad, but he's a fellow podcast host, and I eagerly await when his show comes out. It's one of the top of the queue. This is someone who is on our side. This person was so angry on Friday that they said things that I think are about to make things much, much worse. So let's unpack this exchange. It starts with, hey, F you if you're telling me the solution is to vote. And by the way, spoiler alert, the solution is to vote. But then I didn't reply. That next one, that's not from me. That's just from another person who says, this seems like a weird take, man. And then the original poster does not reply, but the follow-up is from a third person, right, who says, yeah, because we did vote and nothing happened. And I realized there's a tremendous amount of misunderstanding going on, because that third person is right. We sounded the alarms and we shouted from the rooftops and said, you need to do everything in your power in 2020 to go vote to stop a criminally insane game show host from continuing to wreck democracy. And nothing happened, by the way, but that's probably not something I can get into in this whole 501c3 thing. But it's true that nothing happened to prevent the Supreme Court's opinion in Dobbs, because those wheels were set in motion in 2017. Voting in 2020 was too late. Mitch McConnell had already stolen one Supreme Court seat, and the president would get to fill two more with judges who explicitly promised to do what the Supreme Court just did. To make that not happen, you would have had to have voted in 2016, and thank you, a lot of you did. But not quite enough. Some of you did a truly bad thing. Now, let me be clear. I mean bad here as strategically bad given your likely preferences. So let's lay those out. On a political spectrum in 2016, the two candidates who actually won any electoral votes were Hillary Clinton and the candidate to her right, Donald Trump. There was also a con artist and professional grifter running a vanity campaign who ran to the left of Hillary Clinton, and her name was Jill Stein. So there you have it, from left to right: Stein, Clinton, Trump. And then this thing happens that always happens when you have first past the post voting and winner take all elections. Votes for the third party, in this case actually a fourth party, and I'm not going to list all the other random stupid vanity candidates, who cares? Votes for the third party candidate wind up hurting the candidate most ideologically aligned with that person and helping the candidate most ideologically opposed. So, math. In Michigan, Trump defeated Clinton by less than 11,000 votes, and more than 50,000 people voted for Jill Stein. In Wisconsin, Trump won by 22,000 votes, and more than 30,000 people voted for Jill Stein. And in Pennsylvania, the crucial heart of swing states, Trump won by 44,000, and 49,000 voted for Jill Stein. Again, this is just math. I'm not telling you what you should have done in 2016. I'm not saying that Jill Stein cost Hillary Clinton the election. What I'm saying is that if you were a Jill Stein voter, presumably the last thing you wanted was President Trump. And yet, that's what happened. Had those Jill Stein voters cast their ballots for Hillary Clinton instead, it is mathematically the case that that would have swung 46 electoral votes. Trump would have never been president, and 3 of the 5 justices that wrote the Dobbs opinion I just broke down for you would not have been on the Supreme Court. That was your chance to stop it, and it didn't happen. Now, let me be clear what I'm saying here. I am trying to craft a future strategy based on past history. I'm not saying it's Stein's fault. For some reason, this seems to be the first defense that Stein voters give after I give a talk like this. I'm not saying Hillary's campaign didn't suck or that. Look, none of that matters. The question is, did you want Friday's outcome or not? And if you did not want that outcome, the correct strategy would have been to vote for Hillary Clinton in 2016. Now, I cannot explain the Pennsylvania Jill Stein voters, but I actually have some insight into those other two states. This comes from talking to a lot of Jill Stein voters, actually. They were looking at this state's electoral history. 7 wins in a row for Democrats in Wisconsin, 28 years of unbroken success. Wisconsin voted for Michael Dukakis in 1988, and he was a big suck loser, right? Democrats can't lose Wisconsin. Same thing. Michigan, 6 years in a row. Okay, they didn't vote for Dukakis, but they voted for everybody else for 24 years. They voted for John Kerry. They voted for Al Gore. Democrats can't lose Michigan. And so the thought process was, hey, Hillary Clinton's going to win my state. Nate Silver says it's a blue lock, right? So it's not a swing state. I'm going to use my vote as a protest to send a message. You should nominate a more liberal candidate next time. That didn't go great. Historically, people are not good at predicting whether your state's a swing state or not. I mean, Utah, probably not. Right? But past was not prologue for these states in 2016. A state is totally safe until it isn't. But second, never in the history of modern elections have political parties gone back, looked at their margins of victory and defeat with respect to third-party candidates, and swung left because of it. In fact, the opposite happens. Again, I know you don't want to hear this, but this is reality. When you think about 2000, you probably think about Florida, and I can't blame you, right? When I think about it, I think about New Hampshire. Al Gore, who ran probably the most progressive political campaign in modern American history, narrowly lost New Hampshire by about 7,000 votes. 22,198 people voted for Ralph Nader as the protest vanity liberal third-party candidate. So yeah, if a third of Ralph Nader voters in New Hampshire had voted for Gore instead, the shenanigans and the recounts and Bush v. Gore and hanging chads would not have mattered at all. Bush would have had 268 electoral votes with Florida and Al Gore 270. If you've forgotten, Bush is the guy who nominated Samuel Alito to the court, who wrote the opinion in Dobbs that came down on Friday. Now think about each of these elections in 2000 and 2016. Did withholding votes from the Democratic candidate send a message? No! In both subsequent elections, the Democratic Party swung to the right. It said, holy crap, we can't lose this race again. And with the active machinations of the DNC, they put their thumb on the scale for the most conservative Democratic candidate in the field. In 2004, that was John Kerry instead of Howard Dean. I was a Howard Dean volunteer. In 2020, that was Joe Biden instead of Bernie Sanders or Elizabeth Warren. I was an Elizabeth Warren volunteer. So I know a little bit about what I'm talking about here. And that gets to the bottom line. Your vote is not a message. Your vote is the right to choose, frequently between the lesser of two evils that are narrowly circumscribed. And if you don't like that, start working at the grassroots level to get rid of first past the post voting for instant runoffs. But until those rules change, don't pretend they have. So I want to leave you, it's been hard, with another one last stern warning. I know a lot of us are watching the January 6th hearings, and we've pointed and we've laughed at grifters and frauds and liars and incompetent dolts like Sidney Powell and Rudy Giuliani, who kept claiming, even after Joe Biden was inaugurated, that they were going to throw out the whole election and re-vote and get Trump back in office. And surely none of us could be that dumb, right? Well, yeah, that's a Daily Kos article, left-wing news site, from February 2017, 3 weeks after Trump had been inaugurated, breathlessly reporting on the front page about a potentially landmark writ of mandamus that would nullify the 2016 election. It sits on the SCOTUS docket. It was the work of these grifters and liars who have finally taken down the website after my making fun of them for 5 years. Revote 2017. And for the low sum of $25, they would have sent you a printed copy of their completely bonkers petition to revote the election. which I do not have to tell you did not nullify the 2016 election. It was indeed assigned docket number 16-1464 at the Supreme Court, because anything a crazy person files in crayon at the Supreme Court gets automatically assigned a docket number until it gets dismissed, which of course this thing did. So yeah, our side is plenty guilty of wishful thinking and motivated reasoning. So here are my takeaways. Number one, the Supreme Court has abandoned its most important historical justification to protect discrete and insular minorities from majority legislation. Number two, the Supreme Court explicitly hates you in particular. They replaced the centuries-old test with a new one they just made up that says we care only about the historical views of white, male, cisgendered, heterosexual landed property owners. Number three, the last time they did it, they kept at it for 40 years until progressives came back and mustered overwhelming electoral force. We're in year 5. This is going to be a long fight. The right spent 50 years to get to this point. We're not going to undo it by the midterms. That's not how you judge being able to fight back. And number 4, and most importantly, that fight will be longer if you give up, if you drop out, or if you vote third party. Thank you. I am now happy to take questions.
All right, thank you so much, Andrew. We are going to take about a 5-minute break. This way people here in the audience can get some coffee, and this also gives us a chance for everyone joining us on Zoom to get their questions over so we can get them to you as well.
Sounds good.
All right, thank you so much. Oh, and I do want to take a quick moment and just tell you how much we really appreciate you, because for those of you who don't know, this was a very quick, short notice, and so we really, really appreciate Andrew for being available to discuss this on such short notice. So.
Anytime.
This old road is taking its toll. I've been broke down, but now I'm back on the road. Got it in gear, sitting on go, just waiting on the light to change.
I'm going places straight to the top. I'm all revved up and my engine's hot. Just temporarily come to a stop, and I'm waiting on the light to change. I took a little detour, wrong way down a one-way street.
I had to learn the hard way, no shortcut to easy street. I lose my way now and then, but better days are just around the bend.
I'm gonna get myself moving again. I'm just waiting on the light to change.
I took a little detour, wrong way down a one-way street.
I had to learn the hard way, no shortcuts to easy street.
No, 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 both my hands are on the wheel. My turn will come, I know it will.
From now on, it's all downhill. I'm just waiting on the light to change.
I'm just waiting on the light to change.
Things are moving up ahead for me now,
And I'm ready to roll, I'm waiting.
I'm waiting on the light to change.
That's the way we always thought it would be. In the winter lives of September, how we met, decked out like aces, we'd be anybody's bet, 'cause we was cool then. 'Cause we was cool. Stick it here, you stick it over there, but it never fits. And now the hungry night wants some more and more, and you chip in your little kiss. I done all these jokers, but it turned all my tricks. But I swear to God, I thought this one was smart enough to stick it in a cool spell. Stick it into Coolsville. Ooh, Daddy, stick it into Coolsville.
I can go around. If you want, you can one of these, the other side of the room. Yeah.
It helps if I turn on the microphone. All right, everybody. We'll go ahead and get started for Q&A. I'm shorter than Abhishek, so I moved the mic down some. All right. So we'll go ahead and get started with Q&A. My phone's causing some reverb. Our first question that we had... Not my phone. Try again. Here, take my phone away. It might be my phone. Better? Okay. Better? Okay. Got some UFOs. I gave him my cell phone to take away.
No, it's not on your phone.
From Zoom.
Say again?
Testing.
Yeah.
All right.
No.
Nope. Still there. It's Zoom.
Okay.
It might have been. All right. How about now? Okay. This is why we have professional editors to put it on the YouTube page later. All right. Sorry about that, y'all. Okay, so our first question comes from YouTube, and it seems to be Trump did a lot of things with using executive orders. Would some of these Supreme Court decisions be able to be reversed with Biden issuing executive orders?
So that's a fantastic question. I could give another talk about how this Supreme Court is trying to narrow down the ability of presidents to issue executive orders, because that is a very real thing, and Opening Arguments listeners know that I am a huge fan of a conservative Supreme Court opinion that has given rise to a doctrine that we call Chevron deference, and this Supreme Court's about to end that as well. So the war continues. The way to think about it is like this. There are differing levels of authority and then differing potential responses, right? So when the Supreme Court says the Constitution requires something, right? Requires you to let kids work 90 hours a week in the acid mines, then that means there's nothing anybody can do about that. Because if the Constitution requires it, you can't pass a law to the contrary at the state or the federal level. There's nothing you can do. And there's no higher institution to interpret the Constitution than the Supreme Court. Only thing you can do is change the composition of the Supreme Court. Now, sometimes the Supreme Court interprets what a law means. When the Supreme Court interprets what a law means, there is a thing you can do about it, and that is amend that law. Now, that's easier said than done, because one of the things that one of our two major political parties has done is tried to make it impossible for us to pass or amend laws. And then the third kind of area, and this is where the executive orders come in, modern legislation is the result of, in virtually every case, delegated authority from Congress to executive agencies of which the president is the head. Let me give you the example I always use here, which is gun control, right? When in 1996, the Congress passed gun control legislation banning a whole bunch of semi-automatic weapons, they said, hey, we're going to ban the AR-15, but you didn't want to just say, like, we ban the AR-15 in the text of that law, because then manufacturers would just make the AR-15 plus special edition, right? And, you know, paint it pink and, you know, whatever, right? Get around it. And so you would say, we're going to ban weapons that have this criteria, and every year we're going to allow the Bureau of Alcohol, Tobacco, and Firearms to supplement this list with other weapons that they have determined in their judgment are consistent with this legislation. And that's how executive agencies get power. They're delegated to it by Congress. The system that has worked for just about 100 years is the Chevron deference system, in which if it is ambiguous as to whether the agency has the authority to issue its proclamations, then you defer to what the agency has decided. And this Supreme Court is about to replace that with, no, if it's ambiguous, you defer to the courts. Why? Because the courts are run by right-wing monsters. So to pull all that back together, I want to be careful because 501c3 stuff. President Biden has done an amazing amount of work via executive order. Feel free to hit me up separately with respect to that. About as much as you could possibly do in ways that would surprise you, in ways that fight for LGBTQ equality throughout the government. But there's just only so much you can do via executive order.
All right, thank you. All right, our next question.
We have a question from Ken.
Oh, no. Can you hear it?
We have a question from Ken.
Oh.
Hi, thanks for your presentation. This might be slightly off topic, but do you think that Democrats have a chance to make any kind of significant inroads in the Texas legislature for the next election?
Yeah, so the question was, as a practical matter, do Democrats have the ability to make inroads in the Texas state legislature? I believe that very strongly. I am a noted optimist. The reason I gave this talk, I said this in the middle, that I put it together, worked all day yesterday, and was here on about 40 hours worth of notice, is because I see two contradictory things going on at the same time. Number one, I see that those of us who identify as progressive are now a clear majority in not just the nation, but in a number of states that have yet to manifest as blue or purple at the national level. And I see tremendous amounts of disaffectiveness of folks who have looked at what's happened, and I get it, and said, all right, well, this whole political thing is not for me. It doesn't work. Nothing in my speech was meant to suggest that the problem facing us is not a problem engineered and put into place by one particular political party. We know who that is. Okay, I blame the racists and monsters that put that system into place. But the problem is those people did not show up here at Houston Oasis today. They're not watching on YouTube. They don't listen to my show. I can't reach them. I can reach people who are like-minded, who share our values. And all I can tell you is that the math supports what I'm saying. If you are disaffected, if you think it won't happen, then you will stay home and it won't happen. We are racing headlong into that in the 2022 midterm elections. I only have a voice and a platform to people like you. And so all I can say is, that same level of urgency that you felt in 2020, that you felt in January of 2021 in the Georgia runoffs, it sucks that we have to maintain that at that level for the indefinite future. But I put up what our history is, right? So again, I hit a little bit more pessimism there, but yeah, look, the math, the demographics strongly supports Texas being a purple state and massive gains in the legislature, and working at the grassroots is always the best place to get started.
Did you say?
Question over here.
Yes, thank you very much for your time. Question I have is, what is the process by which a decision needs to be made by the Supreme Court? What's the series of events until we get to that point?
So the question was, what's the process for decisions getting to the Supreme Court? I love this question because I think it is implying something that I have talked about on the show, that is a way of bypassing putting legal questions before this right-wing hackery of the Supreme Court. So other than a few edge cases for some of the lawyers out there where the Supreme Court has original jurisdiction in suits between the states and stuff that you don't care about, the Supreme Court has what we call certiorari jurisdiction, right? That is, it takes the cases that it wants. The way in which those cases get granted cert is by what we call the rule of 4. That is, if 4 of the 9 justices say, we should take a look at this case, the Supreme Court will add it to its docket, will grant the writ of certiorari, and that term's left over from, 13th century Saxon. Right? The Supreme Court can only grant cert in 2 kinds of cases. And again, asterisk. I know lawyers love fact-checking me on this, but by and large, there are 2 ways to get to the Supreme Court. Number 1 is an appeal from a federal court of appeal, one of our 13 federal circuits that hear cases, that hear appeals as of right from federal district courts. And that is, and those are cases that are properly in federal courts. So they're either about federal laws or federal constitutional decisions. Or number 2, appeals from a state Supreme Court decision that affects substantive interpretation of federal constitutional rights. So, in other words, if the state of Utah, for example, rules that it is perfectly fine to require everyone to be, all voters to be a member of the Mormon Church, you could appeal that to the Supreme Court and say, yeah, Utah's state Supreme Court has issued a ruling that is contrary to the First Amendment, and then get relief in that particular way. So notice what's not on that list. So stuff that states could do in a negative way, you always have the right to appeal to the Supreme Court. But when a state says a ruling is a right under the state constitution, if they go no further than that, then that decision is 100% immune from review by this or any other Supreme Court ever. And I want to give you a real life example. We talked about this 3 years ago in opening arguments. This is an issue at the ballot box in Kansas in 2022. And that is the Kansas Supreme Court said, we find that the right to an abortion is contained within the liberty clauses of our state constitution. And so if the federal constitution is ever interpreted differently, and gosh, who could see that coming? That does not matter. Abortion will be protected for pregnant persons as an aspect of bodily autonomy in the state of Kansas. Now, at the state level, what you can do is amend the Constitution, and that's what they're trying to do in Kansas. But this leaves a very, very important blueprint, okay? And that is to say, state courts are free to say, our state constitution says no person shall be deprived of life, liberty, or property without due process of law. We have always read it consistent with what the Supreme Court has said. That legal phrase is called in pari materia. But we don't have to. We can say, in our state, that means we're protecting the basic rights that are inherent in the concept of ordered liberty. And I have been urging state Supreme Courts to do that for as long as I've been a lawyer. So it's another way in which there is an avenue to avoid bringing legal questions before the Supreme Court, because you know what the answer is going to be if you bring something up to the Supreme Court. I told you these decisions were 6-3, and you didn't have to ask what that alignment was. You know who the 6 are, you know who the 3 is.
All right, we have one question.
Hi, Andrew. Thank you for bringing up third-party voting and grifting, because my question today is about grifting. One of the current narratives coming from grifters is during Obama administration, the Democrats had a filibuster-proof majority, but didn't codify Roe into law. Can you explain the law around codifying Roe? Also, how can we control the narrative and strategize against that type of talking point?
Wow, great question. So that was the Obama, and I have heard this and talked about this on my show. The Obama administration had a 60-vote supermajority, right? Didn't have to worry about the filibuster in 2009. So why didn't they just codify Roe as a matter of federal law in 2009, isn't it really still the Democrats' fault? And then what can we do about this piece of abject nonsense? So first, here's why it's nonsense. You go back and look at that filibuster-proof majority, and it did not include 60 pro-choice Democratic senators. That included Bob Casey, who was outspokenly pro-life at the time. He has since come around to modify that position to sign on to a law that would protect Roe and put an asterisk by that. But he was asked at the time. So mathematically, no. Anybody who's saying that is just wrong as a matter of history, is also wrong in terms of that's not the way in which you go about using your presidential authority, right? By saying, well, I'm concerned that 13 years from now, a criminally insane game show host is going to steal a Supreme Court seat and wreck this. Like, that's just nonsense. It's crazy. And I sometimes get why those on our side are looking to blame those on our side because they're the people you can do something about. But this is it's just not true as a matter of fact. As to what we can do to prevent arguments like this from happening, in one-on-one, what I try and do is sit down with people and show them the facts, right? Like they will say that, and I will say, okay, think about where you heard that from. I'm going to sit you down and show you something in about 30 seconds. And if I can do this in 30 seconds, I want you to think about why the source that you've been parroting for the past couple of months didn't tell you that, and whether they're a reliable source or not. I can't tell you I have 100% success rate doing that, but it's all I can do. And again, I want to illustrate this, right? I want to emphasize, these people are our friends. They're on our side. They agree with us on 99 issues out of 100. And it's about maintaining that coalition. And all I can do is point out the other side, right? Evangelical Christians showed up to vote for a thrice divorced foul-mouthed philanderer who's never set foot in a church and holds a Bible like it's a vampire holding a piece of garlic, right? Like that, and they did that on the basis of one promise, that he would appoint Supreme Court justices who would overturn Roe v. Wade, and they did that for 50 years. If the other side can stay that kind of lockstep, maybe we can come together with people who aren't, and still support those who don't quite get as much of the progressive agenda as we would all like to be done. I wish I had more on that, but I would say try and treat people with charity, try and show them the facts.
Thanks. All right, our next question is from Twitter. If the Women's Health Protection Act were to pass, would that even stand under the Dobbs decision?
Glad we got the second question, because I got carried away in the political aspect there and I forgot to answer the legal aspect. Remember the three levels of authority that I talked about. The first is interpreting the Constitution. The second is interpreting law, and the third is interpreting administrative agency decisions, delegations of congressional authority. The most Congress can do is pass a law. Now, the way in which the Women's Health Protection Act would work is to say, we as Congress have the authority to regulate abortion. We have that under, because it's a matter of interstate commerce, right? People who are pregnant travel across state borders in order to obtain abortions. That's a proven fact. And we would like to preempt all state laws and occupy the field, right? That is, get rid of everything to the contrary at the state level or below, and replace that with whatever you set to be the standard, right? That there should be no prohibitions on abortion pre-viability of the fetus, for example, which is how I believe the current act is written. That could still be challenged in the Supreme Court in one of two ways. Number one, they could argue that it is not within Congress's power to pass such a law. And if you're thinking, well, they have the whole interstate thing, how could that possibly work? I would refer you to NFIB versus Sebelius, in which this Supreme Court in 2015, right? So a more liberal version of this Supreme Court, in an opinion authored by John Roberts, said that Obamacare, right, that the Affordable Care Act was not authorized as a form of interstate commerce. Now, I can't think of anything that's more interstate commerce-y than medical care, right? Like, people travel, you get drugs from across the borders, people go into and out of states and seek doctors all the time. And this court said, nope, that's not interstate commerce-y enough. So could this activist Supreme Court overturn that by saying, yeah, no, this is an unconstitutional law. Congress doesn't have the power to supersede the state's will on this issue, because this is not really about commerce. This is really about, protecting the unborn, as the Dobbs decision says. They certainly could, and I don't think you have to be where I am now to think where this court would likely come out on that. So yeah, great question.
All right, and I'm trying to keep an eye on the time, so I'm going to ask the last two questions from Zoom.
I'm sorry. You should know better than to try to get me to do a lightning round.
I was like, but we will have you back again very soon, because everyone loves you, so we need to have you back again. But let me. The last two questions. First is from Eric on Zoom. Do you think rank order voting will be required in order to offset the transgressions that led to the current makeup of the Supreme Court?
I love the question. So let me telescope that out a little bit. It's not really that hard to fix the current SCOTUS in conceptual terms, right? All we need to do is double the current size of the federal judiciary while a Democrat is in office, and then gets to appoint all of those members of the judiciary, right? By the way, this is not just a power grab kind of thing. Our judiciary is idiotically overworked. Every judge I know, left, right, and center, would tell you that their dockets are about 100% too crowded. So perfectly defensible, and you would get 9 Supreme Court nominees, and all you need is a 50-vote majority to do that. You'd have to break the filibuster in order to pass voting rights reform and Supreme Court reform, and then you'd have to pass that bill. We don't have that because we have Joe Manchin and Kyrsten Sinema, but we're not that far from that. That's 2, right? We're not that far from being able to make that broad and sweeping a change, and that's all it takes. One act of Congress, the Judiciary Act of 2023. Now, is rank order voting, rank choice voting at the local level, is that a good idea? It's a fantastically good idea, right? And we have the technology right now, and we're not the party that thinks that, Dominion voting machines send your ballots to the ghost of Hugo Chavez to adult. No. Like, yeah, I would love that. I would welcome that. People think that I am anti-third or fourth party. Nothing could be further from the truth, right? For somebody whose political views are to the left of the mainstream Democratic party. We don't have that right now. And the way in which you get that is by agitating and organizing for that change at the local level. But yeah, at that point, if on election day you tabulate it up and it is, 48 for the Democrat and 47 for the Republican and 5 for the Green Party candidate, and then, okay, well, no one's over 50%. Let's add the Green Party candidate to the Democratic candidate. There you go. Congratulations, you win. Then send as many message votes as you want, right? That's how you can transform your vote by changing the way the rules are kept. But right now, that's not the law in virtually every jurisdiction, and that has to be built from the ground up. I tried to go faster then.
And then a good follow-up to that is a question from Roger on Zoom. What would it take to abolish the two-party system?
Yeah, and that's so. Abolish is thinking about it from the top down, right? Is there a law you could pass that would do X? And the answer to that is no. And the way to think about that is the entirety of our nation's history. We've had a couple of inflection points, where the Whigs die out, or where, Republicans go from being sort of the progressive but pro-business party to the party of racists and monsters. But by and large, right, every institution we have since 1800 has assumed that there are going to be two and only two parties. You dismantle that piecemeal from the bottom up, right? By things like RCV, by making it possible. And this is the area where, our friends on the fourth party left are correct. And that is, at that point, the institutions will fight back, and both Democrats and Republicans will be aligned in not wanting to threaten that system. They're right about that, but you can make that not matter by appealing to their self-interest, right? So how do we appeal to self-interest, right? 99% of congressional seats are gerrymandered right now into safe districts, be they safe Democrat districts or safe Republican districts. The people who favor that are incumbents. The people who oppose that are everybody else. And so, that needs to inform you in terms of how you're working at the state level. But that's an overcomable problem. It's a big issue. I would certainly love to see, I think, parliamentary democracies have much more to commend them than certainly our broken system over the past 20 years. And we're going to need to think as outside the box as we can to try and fix what's going on. But I would say the two things I keep saying. Number one, got to be built from the ground up. And number two, until those rules are changed, you got to play by the rules we got. So there we go.
All right. Thank you so much. And I cannot express how grateful we are for you speaking here to us for especially on like you said, about a 40-hour notice. So we really appreciate it. We're very grateful.
It's a pleasure. I'm happy to be here. You have always treated me well, even when I have beat up your members. So I greatly appreciate it. I can't wait to be out there in person.
Yep. Well, again, thank you. All right. So we're going to have a couple songs here in a moment to kind of end our program. I do want to highlight a couple of upcoming events that we have. We do have a card players event that meets on Wednesdays. This week it's at CB and Kevin's house. So if you want information, you can talk to them or Richard Andrews. The information is in the bulletin. And we also have the July-August book club coming up. The date is to be determined, but the book is going to be River of the Gods by Candace Millard. And lunch today is going to be at Fuddruckers. So with that, we'll go ahead and have a couple songs to close us out. And thank you again, Andrew.
Yeah, thanks again, Andrew. I don't really know much about the Supreme Court at all, so that was very eye-opening for me. And yeah, it just really kind of put a lot of things in perspective for me right now about that long, hard, difficult journey. I wrote a song about a long, difficult, uncertain journey. It's called The Lake Song, and here's how it goes. Times like these that it gets hard for me to find the strength to swim. 'Cause something's in the water and it feels like it's about to pull me in. this body, and how easily it soon could swallow mine. 'Cause it's been here for ages, and it still will be here long after I expire. Nothing I can do is gonna save me if I sink and I feel useless. I feel cheap. Wonder if this water standing still is running half as deep as I may think it just might be. And I feel clueless, I feel lost, staring at this lake and waiting for this pebble I have tossed to find its way back to me. Though I'm not sure it's even coming, it just might be. Beneath the surface of this black abyss may lie a precious stone. But if I wish to find it, it's a journey I will have to make alone. Now I'm not even deep, but I'm already feeling the pressure on my chest. Something's telling me to dive in, but I'm not sure how long I can hold nothing I can do is gonna save me if I sink and I feel useless. I feel cheap. Wonder if this water standing still is running half as deep as I may think it just might be. 'Cause I feel clueless, I feel lost, staring at this lake and waiting for this pebble I have tossed to find its way back to me. Though I'm not sure it's even coming, it just might be the last time that I see the surface. But I need to find what's hiding on the floor. I don't know what's at the bottom, but I know I wanna see it. So even if I drown, so be it. 'Cause I feel useless, I feel cheap. Wonder if this water standing still is running half as deep as I may think just might be. 'Cause I feel clueless, I feel lost, staring at this lake and waiting for this pebble I have tossed to find its way back to me. Though I'm not sure it's even coming, it just might be.
That's a Nathan Ray original.
Thank you.
We're going to close with something probably a little more familiar to you, Bob Marley's song. Oh, pirates, yes, they arrived. Sold to the merchant ship. A minute after they took aim from the bottomless pit. But my hand was made strong by the hand of the Almighty. We forward in this generation triumphantly. Won't you help to sing these songs of freedom and all I ever had? Redemption song, redemption song. Emancipate yourselves from mental slavery. None but ourselves can free our mind. Have no fear for atomic energy, 'cause none of them can stop the time. How long till they kill our province while we stand aside and look? We've got to become a part of it. We've got to fulfill the book. Won't you help to sing these songs of freedom and all I ever had? Redemption song, redemption song. Emancipate yourselves from mental slavery. None but ourselves can free our mind. Have no fear for atomic energy, 'cause none of them can stop the time. How long will they kill our prophets while we stand aside and look? We've got to become a part of it. We've got to fulfill the book. Won't you help to sing these songs of freedom and all I ever had? Redemption song, redemption song. Thanks a lot. I'm Joe. This is Nathan. We enjoyed it.
All right, thank you so much. And again, a big thank you to Andrew, and thank you all for joining us here in person, on Zoom, on YouTube. We are really grateful for y'all being here today. Y'all are what make Oasis Oasis. So if you like what we're doing and you're able, you can donate to us online. You can also put some money back in the hat. But honestly, y'all being here, being participants, either online or in person, are what make the community, and we're just grateful for all of your continued actual support. So like coming and showing up, that's what makes, it's what keeps us coming back every week. So all right, with that, have a great week. Join us for lunch at Fuddruckers, and we'll see you next week.